see you all shortly.
Not too long. Hey, we have one on the outbound calendar as well. He wants to take you off.
Got you? Okay, that's gonna be negotiated.
Yeah, just.
Okay.
I've already told him.
Good morning, ladies and gentlemen. This is the State Court of Clayton County. I'm Judge Tammy Long Hayward. This is courtroom 304. This is the jail and arraignment calendar, and I see that we have a gentleman from who's with the Department of Corrections. Is he on the jail calendar or the arraignment calendar?
Judge, I believe that's Mr. Porter on the jail calendar.
All right, I'd like to get started with him if possible, and that way we don't continue to hold up the person who's assisting at the Department of Corrections. Do we have information on Mr. Porter?
Yes, I think we can get a resolution quickly. Would you be willing to go ahead and put the courtroom in a breakout room with Mr. Porter so that I can, and then the prosecutors are going back to their office. And then I will just confirm with them and we should have a plea for that, I believe.
All right, so whoever's assisting Mr. Porter at the Department of Corrections, I'm going to invite you to a breakout room so that Mr. Porter can have a conversation with his attorneys. And then once they've had that conversation and we're back in the main room, we can hopefully resolve Mr. Porter's case. And I appreciate you all for making this happen. All right, so breakout room number 2 is Mr. Porter and the courtroom.
Okay. Yes. Yeah, I just want to make sure
All right. All right, so we'll be back in a moment when the courtroom is back, and then we'll proceed with the arraignment and jail calendars. Let's see, somebody. Mr. Porter, raise your hand and wave at me if somebody's assisting you. Okay. Can you ask them to put you in the breakout room? The instructions should be on the screen. He should be in breakout room number 2. All right. So it seems that they've gotten that done. Okay, we'll be back in a moment. All right, so ladies and gentlemen, I'm gonna, the courtroom is in with the Department of Corrections. I want to make sure we have Mr. Porter taken care of so that we can release them as quickly as possible once we resolve his case. So, you know, that's the intention. As soon as the courtroom comes back, we'll go ahead and start calling the calendar.
What? Oh.
Mr. Lynch, you have an announcement?
Yes, Judge, I believe we're ready to go forward with the negotiated plea for Mr. Porter. I'm just trying to chat with Ms. Ponder to make sure that I told him the correct recommendation.
Okay, so let's start with the arraignment calendar. First on the calendar is Terrell.
Good morning. I apologize. Good morning, everyone. Yes, that was communicated this morning. The state is offering credit for time served.
Yes, Judge, we are
And that
ready.
would be on count 1 and count 3. Count 2. I'm sorry, count 2 will be dismissed.
Okay. Yes, we are ready to go forward with that.
All right, so arraignment calendar. Terrell Raymond Coleman. Terrell Raymond Coleman.
Your Honor, the state will move for a bench warrant bond forfeiture.
Okay.
Your Honor, Mr. Coleman appeared last week.
Okay.
And it was supposed, I haven't been able to reach him this week. It was continued so that he could provide some documentation to myself to provide to the state. I'm not sure if he received an additional notice to return this week. We just asked that he not be issued a bench warrant, so I'd have an opportunity to contact him and find out if he received that information and if I could move forward.
Okay.
Otherwise,
Did you get his contact information last week?
I did.
Okay, and you tried to contact him?
No, Your Honor. I haven't spoken to him since last week, and I didn't have an opportunity to call him yesterday.
Okay, but he was here when I told him he needed to be back this week, right?
He was present in the courtroom, yes, last week.
All right, so bench warrant. I won't issue a bond forfeiture, but a bench warrant. All
Thank you,
right,
Judge.
Keate Darkeese Hatcher.
Yes, Judge, Mr. Hatcher does appear. He is on the Zoom call. That will be a negotiated plea today.
All right, Mr. Hatcher, where are you? All right, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. Sir, you're before the court on 2021 CR 08219. Keontae Darkeese Hatcher, represented by Lister Holton Dennis. Mr. Owen Lynch is your attorney. You're before the court for criminal trespass, count 1, hit and run accident, count 2, wrong side of the road, count 3, obstruction of an officer, count 4, reckless driving, count 5, fleeing from police, count 6, and stop or yield sign violation, count 7. Mr. Lynch, what is your client plead to the offenses before the court?
Judge, she's going to enter guilty pleas today.
2.
Counts 1 through 7.
Okay. All right, sir, by entering a plea of guilty to counts 1 through 7, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am. Well, yes, Your Honor.
Factual basis and recommendation, please.
Your Honor, one moment. If you just give me a few minutes, Your Honor, please. Thank you. Your Honor, thank you for your patience. After looking into this situation further, I believe that this might be a felony, given we have the reckless driving and the fleeing. However, I need to just do a little more research to see. I know this happened in 2021, so I need to just go back to the rule to see if at the time of the incident, this would have been considered a felony, because if so, then we might need to transfer this case up. So it's asking for a little bit more time to do a little more research into this, just to make sure.
Okay, but y'all
have the
got a
proper-
negotiated plea that was, didn't y'all get a plea? Didn't y'all negotiate this?
We did, Your
why
Honor.
why we didn't figure that out before we negotiated this?
And yes,
Just a-
ma'am, I do understand. Yes, I do understand, Your Honor. It was just brought to my attention. So just asking the court for a few more, just some time to go to
No,
research this to make sure
No.
that.
no.
Okay. Not a problem, Your Honor. I will proceed forward as is. As far as the factual basis, on or about May 17th of 2021, Deputy C. Wright of the Clayton County Sheriff's Office heard Deputy Thompson attempting to initiate a traffic stop via radio on the defendant's vehicle. During that on that incident, Deputy Thomas observed the defendant changing lanes rapidly at a high rate of speed. The defendant was also observed fleeing from Deputy Thompson on Terra Boulevard north at Flicker Road while Officer Wright was traveling on Terra Boulevard south of Flicker Road. Officer Wright attempted to activate emergency equipment, and the defendant drove through the center median in front of his patrol unit and drove north in the southbound lanes on Terra Boulevard. The defendant proceeded to turn left onto Flicker Road. Deputy Thompson proceeded to pursue after the defendant. The defendant failed to yield to Officer Wright's emergency equipment. At that time, the defendant drove through several stop signs while fleeing from Officer Wright in his vehicle at a high rate of speed. The defendant lost control of his vehicle when his vehicle hit the driveway of 10111 Commons Way, went airborne through the yard and landed on Commons Court. Officer Wright observed the defendant jump out of the vehicle while it was still in motion and fled the scene on foot toward the rear of 10118 Commons Court. At that time, Officer Wright observed the defendant exit the driver's side door. The vehicle then struck and completely damaged the entire mailbox of 10118 Commons Court and came to a stop in the bushes located on the corner of 10118 Commons Court. At that time, the defendant was captured shortly after he fled the scene. The defendant was captured at 10297 Hampton Glen. And Your Honor, those are the facts of the case. The incident did occur in Clayton County, Georgia. Your Honor, for count one, a fine of $100. For count two, the hit and run, 12 months probation, a fine of $300 and 40 hours of community service. For count three, a fine of $100. For count 4, a fine of $300. For count 5, a fine of $300. For count 6, a fine of $1,000, and for count 7, a fine of $100.
All right, how many consecutives am I gonna have to do, Mr. Lynch, for him to be able to pay this?
I guess that, I'm not, if it's a total, it's a large amount, Judge.
It's a very large amount. 1, 2, 3,
So-
4, 5, 6, 7, 8, 9, 10, $11, $2,100 without surcharges. $2,100 times 30%, just as a round number, 2730. So we're
Mr.
looking at
Hatch,
almost $3,000.
Can you get that paid within 1 year?
And I apologize for interrupting the court. I believe for count 6, there is statutory minimums for that pre-June 2023. Which requires, and I'm not sure if there was any jail time done prior, but I believe specifically for count 6, if the defendant intends on pleading to count 6, it will require a statutory minimum of some jail time and a fine.
How much jail time, Ms. Ponder?
And it's my understanding, Your Honor, June 2023, it's 10 days. And
All right.
also the fine minimum is 500.
Okay, well, he's got $1,000 fine, so the 10 days credit for time served. All right, so let's talk about these fines. Mr. Hatcher, what you doing with your life now, sir?
Right now I attend UEI. I'm trying to get my HVAC certification, and like when I'm not at school, I'm cutting hair. So
Okay, so you know how to hustle. That's my question. Because, folk who don't know how to hustle, they're going to always be running behind in this world. I firmly believe in the hustle, the legal hustle. So HVAC and cutting hair, you can get this knocked out. I don't know if you can do it in a year because you're still in school. If you were working full time, I would say all day, no problem. But you're still in school, which I applaud that because I've paid for HVAC and I know how much HVAC people make. And we got a good friend who's always looking for folk. But the problem is once people learn it, they always want to go out on their own. And so it's a good job, good business. You got to have a good business mind, Mr. Hatcher. And if you have people that you work with, if you don't disappoint them, they will continue to send you business and to continue to use your business. You understand that? So
yes,
be
sir.
business minded. Don't just be lackadaisical, get the hook up, all of that. Be a businessman. If that's what you're going to do, be a businessman.
Yes.
Now, back here in 2021, 2020, when this all happened, you ain't have nothing going on, did you?
No, I just graduated from high school. I had got my first car. I was young. Looking back on that situation, I definitely regret what I did. But I learned from that lesson. I never put myself in that type of situation again. I've had a child since that incident. Got married since that incident. So I just feel like, it's been 4 years ago. I'm a changed person. I was,
I get that. All right. So this is what we're going to do. We're going to, I'm going to accept your plea of guilty to count 1, count 2, count 3, count 4, count 5, count 6, count 7. Now we're going to, on count 1, we'll run concurrent with count 2. That's a $100 fine. Count 2 is 12 months probation, a fine in the amount of $300 and 40 hours of community service. Count 3 is a $100 fine. Count 4 is a $200 fine. They will run concurrent with count 1. Count 6 is a $300 fine. Sorry, that's count 5. Count 5 is a $300 fine. Count 6 is 12 months to serve 10 days. I'll give you credit for time served. Balance will be probated to pay a fine in the amount of $1,000. And then count 7 is a $100 fine. So count 5, 6, and 7 will run concurrent with each other. And then count 6 will run consecutive to count 2. So that should give you 24 months to pay all of the fines and fees, okay?
And Your Honor, for count 4, did you have $300 for count 4?
I believe, yeah, I did say that.
Okay, thank you.
Yeah. Do I have
Okay.
300? Yeah. Do I have $300? I'm sorry, I may have said 200 because my writing looked kind of goofy. Let's see. If you pay $150 a month, you can knock that out in 20 months. If you pay more than that, so your minimum is going to be $150 a month. That's the minimum that you are required to pay for probation. You understand? Okay. So you can pay more. If you get some lump sums, I would throw that in there and start paying more and pay it down quicker, because the quicker you get it paid off, then I will, if you get it all paid off in whatever time, then your probation will terminate. Okay?
Thank you.
All right, because I'm willing to work with you. I understand this was 4 years ago. You have changed since then. I don't have anything else listed on my calendar for you, and you've gotten married, got a child, going into business, got another business. Let me just tell you, that's a successful husband and father, somebody who knows how to bring in multiple streams of income. I wish everybody knew that. You can't just be dependent upon one thing. We clear?
I appreciate that, Your Honor.
And as long as you got skills, barbering and HVAC, as long as you got skills, you ain't gonna never go hungry. So just remember that. All right. So Ms. Wright, I know that was confusing, so I'm gonna say it again. Counts 1, 2, and 3 will run run concurrent. Counts 4, 5, 6, and 7 will run concurrent, and then count 6 will run concurrent to count 2.
It's a consecutive count 2. Count 6 should be consecutive, Judge.
I'm sorry, count 6 will run consecutive to count 2. Okay. All right, is that acceptable, Mr. Lynch?
Yes, Judge.
But if you get it all paid off beforehand, your probation can terminate. All right.
Yeah.
All right. So, Mr. Patrick, I wish you well. What I'm going to do now is put you in a breakout room with the probation expert, Ms. James. Ms. James is going to explain anything that you need to know about probation. So you have to report as long as you're on probation, which means that you want to pay these off as quick as you can so you don't have to report. But with pay only probation, the two things you need to do are pay and report. You understand? Pay and report. Those are the only two things. And you are paying a minimum of $150 a month. All right. So I'm going to put you in a breakout room with Ms. James. Ask her any questions that you might have regarding probation, and she can answer any of those questions for you. But also realize that the quickest way to get rearrested or to have problems is to not report for probation. If you're having any kind of trouble, talk to your probation officer. They are very compassionate people who help their people successfully complete probation. Okay, so don't run from them, because if they figure like they can help you and all they need to do is change a few things or tweak a few things, they'll talk to us about it. Okay.
Yes, Your Honor, I appreciate that greatly.
All right, so I'm going to put you in the breakout room with Ms. James. You do not have to come back to this room when you're finished. You can just go ahead and get started on whatever you all talk about. All right.
Thank you, Your Honor.
You're welcome. Breakout room number 5. And all righty, thank you.
Excuse me, Judge.
Yes, ma'am.
You just said pay only. Are they all except for the one with community service pay only?
Yes.
Thank you.
All right. All right. Next.
Would you like to go forward with Mr. Porter to get the Department of Corrections out of here?
Yes. Are we ready on Porter?
Yes.
State is ready, Your Honor.
All right. Mr. Porter, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right. You can put your hand down, sir. All right. Mr. Porter, you're before the court for case 2022 CR 00148. Antario Lamar Porter for driving on a suspended or revoked license, count 1, no license, count 2, and stop or yield sign violation, count 3. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, no contest to count one, no contest to count three. Count two would be a null process.
All right. All right. So, Mr. Porter, by entering a plea of nolo to counts 1 and 3, count 2 will be no pros. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right. Factual-based recommendation, please.
Yes, Your Honor. On July the 22nd, 2021, officers conducted a traffic stop at the intersection of Kendrick Road and Essence Drive, located here in Clayton County, Georgia. After officers observed the driver of the vehicle failing to stop at a stop sign, officers later determined the driver of that vehicle, later identified as Ontario Porter, was the driver at that time. Officers learned during a check of his GCIC that his license were suspended as of May 29, 2018. Those are the facts of the case, Your Honor. The state's recommendation for count 1 and 3 to run concurrent, 12 months to serve, 10 days credit for time served, balance suspended. Count 2 will be no pros, Your Honor. Additionally, Your Honor, the state will prepare a bench warrant recall.
All right. So, Mr. Porter, I'm going to accept your pleas of nolo to counts 1 and 3. 12 months to serve 10 days, credit for time served. The ballots will be suspended as long as you have no new violations of the laws of the state of Georgia. That's the sentence for both 1 and 3 to run concurrent, and count 2 will be no pros. All right, and we'll do the, all right, and I'll do the bench warrant set aside so that you're finished there, then you'll be finished here, okay?
Yes, ma'am. Thank you, Your Honor.
You're welcome, Mr. Porter. Mr. Porter, I don't want to see you in any kind of jumpsuit unless you're working under a car or doing some kind of hazmat work. You understand?
Yes, ma'am.
All right, let's get it together.
Thank you.
You're welcome. Anything else for Mr. Porter?
No, Your Honor.
Nothing further from the state, Your Honor.
All right, thank you for the assistance from the Department of Corrections. Mr. Porter's free to go.
Okay.
All right, so the last case on the arraignment calendar is Mr. Maple, Lucius Maple. Good morning.
Hey, how you doing, Jim?
I'm good.
I have my attorney, Mr. Dark, with me.
Mr. Dark? Hello?
Yes, Your Honor, I'm here. I'm trying to get my video sorted, but I am here. I think the court can. Judge, can you hear me?
I hear you, but I sent you a prompt to start your video and it said you will start your video later.
Oh, I clicked the wrong one. It says, okay. All right, here we go.
Dark, I thought you were a myth.
No, I'm not, Your Honor.
Okay, so
I think I must have.
Attorney, are you gonna file an entry?
That's what I was saying. I think I must not have been actually receiving notices, but
You
I
didn't
will
file
go ahead
an
and.
entry. We don't, Mr. Dark, I'm about as psychic as they come. But unless you file an entry, I am not going to send you a notice because I don't know that you're his attorney.
And Judge, my apologies on that. I think there was maybe some mix up. This case was originally bound over from the city of Amaro, and my understanding was that the entry would travel with, but
it never
obviously
does.
that
Please
didn't.
don't rely on that. It never
Yeah,
does.
that didn't happen. So I'll get that in today. so that we can get going. I will say that I do have most, if not all, of the discovery, and we're in a posture for. I guess I need to speak with the prosecutor to see if we can resolve this short of trial. But if not, of course, I would not want to waste the court time. We can go to the next or thereafter trial calendar.
Well,
If
Mr. Dart, this is what I say. First, I need you to file an entry. If you can get that done today, that would be appreciated. Second, is your client entering a plea of not guilty pending your pretrial with the state?
yes, Your Honor, we'll enter a entry of not guilty and request 10 days to file any appropriate motions.
All right. So these are my rules. These are Hayward rules. I don't like my people who are here all the time know this is how I roll. If you file a not guilty, I don't mind you doing motions. We had motions hearings yesterday. I don't care. What I do care about is folk who file a not guilty and then disappear. And then we never hear from them again and they never pre-try the case. The solicitors are here all day, every day. So please make sure that you don't file a not guilty and just disappear. I need your entry and I need you to pre-try the case. If it goes to trial, fine, I'll give you a good trial. If it goes to a plea, fine, I have multiple opportunities for you to take a plea, but I don't want to waste time.
Thank you, Your Honor. And I sent a message to, I believe, Ms. Ponder but I'm not sure who would be the solicitor, but I'm just trying to make contact with the solicitor. And so I'll certainly pre-try this case with them as soon as I'm able to.
And
Yes,
also
Attorney
make
Dart,
sure,
I am the prosecutor on the case and I've responded to your message.
Okay,
make sure
thank
you
you.
view any videos, body cams, whatever, because when we get to trial, I'm not hearing, well, I didn't get everything.
I understand, Your Honor.
Okay, ask around. People will tell you how I roll. All right. So you're entering a plea of not guilty for your client. Is that my understanding?
Yes, Your Honor.
All right. So Mr. Maple, please keep in touch with your attorney. Your next your next calendar date will probably be a calendar call for the trial calendar. So you can be available for that. All trials are in person. So when you are called to trial, your trial will take place in courtroom 304 of the Clayton County State Court in the Justice Center on Tierra Boulevard. Okay. So let's just be clear on that. Anything else? Any questions?
No, ma'am.
All right. So I look forward to seeing you again, Mr. Dart.
Yes, Your Honor. I will be filing that in today. Thank you so much.
All right. Take care. All right.
You
Jail
too.
calendar.
Your Honor, I have an announcement
Yes.
before the jail calendar.
Sure.
Mr. Coleman's present.
All right. What's up with Coleman?
So, Your Honor, I'd like to have a conference with the state. We can do this after the jail calendar. But Mr. Coleman thought this appearance was at 11 a.m. So he's
You
running.
need a pre-trial with the state with who? Ms. Ponder or Ms. Hagler?
This will be, I believe, Ms. Hagler.
Okay. I'm gonna put you in a breakout room right now because when we roll on the jail calendar, I want to just go ahead and do as much as we can straight through. All right. So Ms. Hagler is in room 3. The courtroom is in room 3, and then we'll come back and do the jail calendar. One
Yes, Your Honor.
second. Don't go into the courtroom yet. I mean, don't go into the breakout room yet. I need to move you. There we go. All right.
Okay, thank you. Our next motion is calendar. We follow the meeting.
Mr. Lynch, Mr. Taylor, we ready? Ms. Taylor, Ms. Ponder?
Yes. Oh, my apologies, Your Honor. We're finished with the breakout room with Ms. Hagler, and we're both back in the courtroom.
All right. All right, so first case on the jail calendar is Agra.
Judge, I believe that person's at demand.
Sorry.
And Your Honor, we're moving to dismiss that case.
All right, so that case will be no pros and the person is OTP. All right, Bright, Fatima, Bright.
Judge, that will be a negotiated plea.
Anthony Lamar Brooks.
That is Mr. Taylor's case. What's he now?
He's up for a bond revocation motion.
Oh, okay, so he's here on a motion, Judge.
The state's motion.
The state's motion.
All right, Anthony Lamar Brooks has two cases. Collier, Preston, Kamey, Collier.
Judge, I may have to, I'm trying to talk to him one more time. If we could hold for an announcement. I had some difficulties this morning.
Okay. Chantrell Ellis. Chantrell Ellis.
That's, yes, Your Honor. Your Honor, I just spoke with Ms. Ellis. This case appears to be transferred from Superior Court.
Mhm.
And she has two cases before us. One of the cases has a bond, but the second case does not have a bond. And this is the first time she's been offered, given an opportunity to appear before the court. So we'd ask for the state or ask for the court to set a reasonable bond for the second case, which I believe is 2025 CR 02952.
Okay, you all are entering not guilty pleas for all three?
To both cases, to all three charges.
And Attorney Taylor, did you file a motion for bond on the other cases? If so, I don't have a copy.
Okay, why was she no bonded?
Your Honor, I'm sorry?
Why was she no bonded? Because I've rarely seen prostitution cases be felonies, so I'm not sure why she was in Superior Court to begin with.
That I do not know. I just know that
It started out, I think, as a trafficking. So that is why it was in trafficking of
Okay, yeah, the
persons.
trafficking she would
So
have
that's
given.
why. Mhm.
but the cases have been accused as pimping on this case and prostitution pimping, prostitution keeping the house of ill repute.
Okay, what kind of bond did she get on one of the cases? What bond does she already have?
$20,000, Your Honor. And that's for the case 02949. And she's been in custody for over 3 months now. Her intake date was December 19th of 2024.
Your Honor, the state would just object to giving the defendant a bond on the other case. The incident dates are pretty close in time. I know that the case ending in 02949, that happened on May 1st of 2024. And then the second case happened on May 8th of 2024. So she does have, an open case for pretty much the same cases. And so the state will be asking that the judge do not set a bond for that other case.
But it's a misdemeanor, Ms. Hagler. She's entitled to a bond if it's not. I mean, I get that the Ayala issues would be a factor in the sense of, especially if it was a Superior Court or one of the 7 deadlies. But misdemeanors, bonds are the default. No bond is an extraordinary.
Well, Your Honor, if you are inclined to set a bond, the state will be asking for a bond of $50,000.
I would point out, Your Honor, that she was arrested under a warrant. It wasn't that the police went and investigated an incident as it was occurring or saw an incident. They got information and they sought a warrant and executed a warrant. So they sought a warrant for 2 separate days. It's not like the person was arrested and went out and committed another.
All right. Okay. She already got a $20,000 bond. I'll set a $3,000 bond per charge on the second case, 02952. So she'll have $3,000 on the first charge, $3,000 on the second charge.
Yes, Your Honor. Thank you. And that, again, that's not guilty for both cases.
Okay. All right. Gay. Dominique R. Gay, criminal trespass.
Judge, that's a negotiated plea.
All right. Leon Good Jr.
Judge, we're going to enter a not guilty plea today.
All right. You reminded them of the bond rules. My bond speaker.
Judge, I will. This occurred Yes, I will, he shouldn't, the alleged victims in this case are not people he should be having contact anyway, but I will reiterate that to him.
Well, Mr. Lynch, I mean, isn't that always the case?
I mean, what I mean is it's not
Family.
he has no relationship. This is an incident that allegedly occurred on a MARTA bus, Judge. I will remind Mr. Good that he is to have no contact with the alleged victim in the case.
All right. Tammy Jackson.
Judge, that's going to be a negotiated plea.
All right. Clarence Lucius Mangrum.
Judge, that's a negotiated plea.
All right. We already did Mr. Porter. Hubert Lee Riddle.
Is that person?
That's OTB, Your Honor.
Gabriel Sheely.
Judge, we're going to plead not guilty today.
They get the speech.
He gets his, okay.
How far? Yeah. Bring Mr. Sheely out because I need to look him in his face. Walsh.
Judge, that's a negotiated plea.
And Watt.
It's a probation revocation, Your Honor.
All right. Are we ready on Watt? Okay, hold on. Oh, all right. So just tell me, are we doing males first, females first? What are we doing? Whatever is easiest for Deputy Whitson.
Let's do females first.
Okay, so while we're doing the females, let's make sure we have somebody talking to Watt, so that we can do them all and he doesn't have to go back and forth.
Your Honor, that Miss Watt is female and she's here on the probation violation.
Right, but what I'm saying is, I thought you said that you hadn't spoken to her yet.
I've spoken to her. I just didn't have the recommendation from the probation.
Okay. Mr. Carmichael, if you could just chat that over so we'll be ready when we reach her.
Yes, Your Honor.
All right, thank you.
May I have a breakout room with Officer Dorsey, please?
Who's Officer Dorsey?
He's on our motion to revoke calendar. I just need to speak with him briefly. He did request if we can handle this motion to revoke bond soon because he was working overnight.
Okay, we'll work Officer Dorsey in here. Room 1 for Officer Dorsey and Ms. Ponder.
Thank you.
We'll go ahead and do a plea for Ms. Bright since that's a Ms. Hagler case. And
okay.
She's a female, right?
All right. All right, Fatima Bright.
It's gonna be no low plea.
Present time, sir. Welcome forward.
All right, Ms. Bright, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand down. Is it Fatima or Fatima?
Fatima.
All right, so this is 2021 CR 08 for Fatima S. Bright, who's represented by Mr. Owen Lynch with the law firm of Lister, Holt, and Dennis. Ms. Bright is before the court for obstruction of an officer and criminal trespass. Mr. Lynch, what does Ms. Bright plead to these offenses?
Judge, she pleads no contest.
All right, by entering a plea of no load to counts 1 and 2, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Ms. Bright?
She asked if you understood.
Yes, I do.
All right. Factual basis and recommendation, please.
Yes, Your Honor. On or about March 25th of 2020, Officer E, as an elephant, Boswell, responded to the Howard Johnson Hotel located at 1551 Phoenix Boulevard, College Park, Georgia, Clayton County, in reference to a verbal dispute. Upon arriving on the scene, Officer Boswell spoke to the hotel management, who informed him that the defendant, who was in room number 525, was disruptive and wished to have the defendant removed due to a previous arrest and trespass notification. Upon making contact with the defendant was argumentative and did not comply with the officer's request, and she became very combative as she was being detained by spitting and kicking on the officers and clenching her hands to avoid being handcuffed. Your Honor, those are the facts of the case. The state's recommendation for count 1 is a fine of $300, and for count 2, 12 months probation, a fine of $100, and the defendant is to stay away and to not return to the incident location, again, the Howard Johnson Motel at 1551 Phoenix Boulevard, College Park, Georgia, 30337.
And Judge.
All right, Mr. Lynch, does she have money?
No, Judge, and I did, looks like I made a oversight here. My understanding was a suspended sentence because I just saw just the only condition of being do not return. And I do not believe that she's been in custody for about 8 days, I believe. Do you have any ability to pay these fines?
All right, Ms. Hayward, I don't think she has a job. Ms. Bright, you have any source of income?
I am self-employed. I'm a hairstylist.
Okay, how's that going?
Well, I'm in the process of moving, so I'm not focused on doing hair at the moment.
All right, are you home-wise, are you stable?
No.
Like, you said you were in the process of moving, you were at the Howard Johnson, which suggests like there's some temporary housing issues. So is that what I'm talking, what we're hearing?
Yes, when I went to the Howard Johnson in 2020, that was only like my first week in Georgia. So I'm not understanding what previous arrest guys are talking about if this was my first arrest.
Okay, where are you from?
I'm from Philadelphia.
Okay, are you planning on staying here in Georgia?
Yes.
Do you have anyone that can help you or assist you to get stable?
Yes, I'm already in the process.
Okay, all right, so this is what I'll do. So I'll accept your plea of no. The fine is $300. I'll turn that into 30 hours of community service. And then on count 2 to run concurrent, 12 months probation, a fine in the amount of $100. I'll turn that into 10 hours of community service, so 40 hours total. And you're not to go back to the Howard Johnson at 1551 Phoenix Boulevard, College Park, Georgia, Clayton County, okay?
Your Honor,
Did you have any things that were still left there?
No, I have not been there in 5 years.
Okay, you're good. What now, Mr. Lynch?
I was gonna ask if you consider waiving probation fees and
I'll
allow.
waive the probation fees. And, so all you have to do is the community service and attend your probation reports, okay?
Okay.
All right, thank you.
Thank you, Judge.
Who's next?
Your Honor, the state is ready on Anthony Brooks' case whenever council's ready.
Y'all ready on Brooks? We're trying to do the females, but are y'all ready on
I
Brooks?
think, Mr. Taylor needs just a few more minutes to prepare for Mr. Brooks, my understanding.
Okay. Who's next? So I have remaining Collier, Gay, Jackson, Mangrum, Walsh, and Watt. You know you're muted, right?
Sorry, Judge. I think out of those names you just announced, everyone was a plea other than Collier, who I need to follow up with.
And Watt.
And Watt is the probation.
Right. All right, who says?
This is Miss Tammy Jackson, Judge.
All right, Miss Jackson, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. So Miss Jackson, you're before the court on State of Georgia versus Tammy Jackson, 2025 CR 02259 for one count of terroristic threats and acts, and one count two is battery, simple battery on a police officer. Mr. Owen Lynch is representing you, Ms. Jackson. Mr. Lynch, what does your client plead to the offenses before the court?
She does plead guilty, Judge.
All right. By entering a plea of guilty to counts 1 and 2, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am? Miss Jackson?
Yes.
You understand those rights that I've told you?
Yes, ma'am.
All right, Ms. Jackson. Factual basis and recommendation, please.
Yes, Your Honor. On or about January 24th of 2025, Officer Mondre, Mondre, last name Rambo, was conducting routine feeding in housing unit number 1, section 2 of the Clayton County Jail. While distributing lunch trays, Officer Rambo made contact with the defendant, who was located in room number 1211. Officer Pruitt was also present at that time. As the lunch trays were being handed out by inmate workers, Officer Rambo observed the defendant appear visibly angry upon receiving her tray. The defendant directed her frustration at Officer Rambo and Officer Pruitt, stating, quote, "If I had a shank, I would stab y'all," end quote. Her statement was threatening and it escalated the tension in the situation. At that time, Officer Rambo instructed the defendant to step back into her cell to de-escalate the situation and ensure safety. However, as Officer Rambo attempted to close the door, the defendant intentionally spat on Officer Rambo, striking Officer Rambo. Despite repeated instructions to comply, the defendant continued her hostile behavior. Your Honor, those are the facts of the case. Your Honor, the state's recommendation for count 1 is 12 months to serve, 6 months community time served, balance suspended. And for count 2, 12 months to serve, 6 months community time served, balance suspended, to run concurrent with count 1. And it also appears, Your Honor, the defendant has been in custody since 2023 on aggravated assault charge. So that is the reason for the state's recommendation.
Right. Anything on behalf of your client, Mr. Lynch?
No, Judge, you did just get a little quiet there, but I did speak to Ms. Jackson, and I believe she understands the nature of the charges against her. She has been in custody for some time. We're just asking the court to accept the state's recommendation at this point and give her credit for time served.
Yeah, I was just reacquainting myself with the concept of a conditional threat, but hey, y'all worked it out. So Ms. Jackson, I'm going to accept your plea of guilty to counts 1 and 2. I'll send you to 12 months to serve 6 months credit for time served. Balance will be suspended as long as you have no new violations of the state of Georgia.
Okay.
Count 2 will run concurrent with count 1, same sentence.
So what time, sir, was?
So credit for time served on our offense, on these offenses, but you know you still have stuff pending in Superior Court, is my understanding. So you still have stuff upstairs with the other judges. All right. You can go back with the sheriff's office.
Do I still have to be in this jail? I didn't do anything. That man beat me up. Why I gotta be in jail? Get me out. But I'm still be in jail.
Right, until the other case is resolved.
All right, Mr. Lynch, she already has an attorney upstairs?
I'm sorry, Judge.
Does she already have an attorney upstairs?
I have a public defender.
Okay, does she have any cognitive issues? Possibly. Okay, so yeah, just communicate with her attorney if you can, and she can go back to the jail. Next.
I think that's all the female pleas we have for now, right? Yeah. Can we do Mr. Gay next?
Okay, how are we doing on Brooks?
On Brooks?
Yeah.
Did you ask? Let me
So we
check.
can do Gay next. I'm just asking for an update. Are we ready soon on Brooks?
I think Mr. Taylor's currently talking to him, so he should be getting ready pretty.
Okay, that's fine.
I'm gonna pull out Gay.
Also, Mr. Lynch, I'm going to send a message to the courtroom for Mr. Taylor regarding Mr. Brooks' case, okay? Thank you.
I'll make sure he gets the message.
Thank you.
Yes.
This is Mr. Dominic Gay. Is that correct? All right. So, Mr. Gay, you're before the court on 2022 CR 00399 for criminal trespass. Dominic R. Gay, represented by Attorney Owen Lynch of the law firm of Lister, Holt, and Dennis. Mr. Lynch, what is your client plead to the offense of criminal trespass?
No contest, Judge.
Internal plea of nolo, sir. You give up the right to have a trial. I'm sorry, did I swear you? Mr. Gay, hold your right hand up for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down, sir. By entering a plea of nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself, and sir, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right. Factual basis recommendation, please.
Yes, Your Honor. On or about this February 13th of 2021, Officer T. Reed, R-E-I-D, responded to East Bowling, B-O-W-L, I'm sorry, responded to 130 Indian Lake Drive, Clayton County, Georgia, in reference to a domestic disturbance. Upon arriving on the scene, it was determined during the officer's investigation that the defendant did commit the offense of criminal trespass by entering the premises of the victim in this case, Miss LaQuantika, L-A-Q-U-A-N-T-I-K-A, Lamar, after receiving notice from the victim that entry onto the premise was forbidden. On the 13th, the defendant was advised by the victim while in the presence of law enforcement officers that he was no longer allowed at the victim's residence. On February the 14th of 2021, the defendant returned back to the victim's residence. Your Honor, those are the facts of the case. Your Honor, for count one, the state's recommendation is 12 months to serve, 4 days, community time served, balance suspended, and the defendant is to have no contact with the victim, Miss L-A-Q-U-A-N-T-I-K-A, Lamar, and to stay away from the incident location, which is 130 Indian Lake Drive. The city is Morrow, Georgia.
Mr. Lynch?
Yes, Judge.
What's the connection?
Ex-girlfriend, per the police report.
All right.
My understanding.
Mr. Gay,
Yes, ma'am.
X means X. You can't just pop up and show up on the ex-girlfriend's property, okay? She doesn't want any contact with you, and that's what the court is going to order. So I'll accept your plea of nolo, 12 months to serve 4 days, credit for time served. Balance will be suspended as long as you do not have any contact with LaQuantika Lamar. You not to have any contact directly with her through social media, through any member of her family or friend. Do not reach out to her through a third party. Don't call, don't text, don't go. You understand?
Yes, ma'am.
All right. And then do not go back to 130 Indian Lake, Morrow, Clayton County, Georgia. If you were to violate my sentence of no contact, you could be rearrested. You could have the remainder of your sentence spent in jail. And you could also be charged with additional misdemeanors or felonies. Do you understand?
Yes, ma'am.
All right. X means X, Mr. Gay. You can go back with the sheriff's office.
Thank you, Judge. You do Walsh next. We're still waiting. Oh, wait, I'm sorry, that's Deputy. No, can we do Walsh next?
I'm with whoever's ready. All right. All right.
This is Mr. Walsh.
Mr. Walsh, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. You're before the court on case 2025 CR 02490, Joseph Shatran Walsh. You're before the court for criminal trespass and possession of a drug-related object. You're represented by Mr. Owen Lynch with the law firm of Lister Holton Dennis. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, he pleads guilty.
By entering a plea of guilty to counts 1 and 2, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Walsh?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On February the 26th, 2025, officers were patrolling the area for responded, to a disturbance at 132 Parkway, Forest Park, Georgia, which is the racetrack located here in Clayton County, Georgia. When officers arrived on scene, they made contact with the defendant, later identified as Mr. Walsh. Officers learned during the course of their investigation that the defendant was, as officers indicated, harassing customers for money and walking up to different vehicles at different pumps after having been previously issued a criminal trespassing warning by another officer on October the 11th, 2024. Further, Your Honor, when officers made contact with the defendant and placed him under arrest, officers did suspect at that time a crack pipe, which was a clear pipe that was burnt and used. That is the facts of the case, Your Honor. The state's recommendation is 12 months to serve, 15 days credit for time served, balance suspended, on the condition that he does not return to the business racetrack at 132 Forest Parkway, Forest Park, Georgia, and zip code 30297.
All right, Mr. Lynch, anything on behalf of your client?
No, Judge, I just asked the court to accept the recommendation from the state.
All right, so Mr. Walsh, the people are trying to run a business and folk don't want you walking up on them. So do not go back to the racetrack. Do you understand?
Yes, ma'am. Not a problem. You won't have no more problems for me.
All right, 12 months to serve 15 days, credit for time served. Balance will be suspended as long as you do not go back to the racetrack gas station at 132 Forest Park Parkway, Forest Park, Georgia, Clayton County. Count 1 and 2 will run concurrent. You can go back to the sheriff's office, sir.
Attorney Lynch, can you
Yes,
please let Attorney Taylor know that I sent him a chat directly to him? Thank you.
okay, sure. He said it hadn't come through yet, but
The chat on Zoom hasn't come through to him? Okay. Well, I'll just send it to the courtroom then. Thank you.
I guess,
Oh, I understand, Warner. Ms. Taylor,
Yes.
answer to your question was reasonable trucking by Coleman. I inadvertently regarding this.
I'm sorry, I couldn't hear you. I think it cut off. What was your, oh,
Mr. Coleman's business, the one that's using the Clayton County address, is called Reasonable Trucking by Coleman. And thought I'd replied to you via chat. However, I
Mm-mm.
inadvertently sent it to a Miss Sanchez. That was on the call.
Okay, but
Hopefully,
it's called, are you gonna just, but you said it's called, you,
Reasonable Trucking by Coleman. And Your Honor and Ms. Ponder, I did receive the new recommendation from Mr. Brooks' 2 cases, and we intend to enter a plea based upon that new recommendation that you put in the chat window.
Okay.
All right, is he ready?
And just for confirmation, Attorney Taylor, is that for both cases?
For both cases.
Okay, okay, thank you.
Thank you. Your Honor, I believe there's another gentleman that's ready to enter a plea first.
Yeah, this is Mr.
All right.
Mangrum.
All right, raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, sir.
All right, you can put your hand down. Who's this gentleman?
It's Mr. Mangrum.
All right, Mr. Mangrum, you're before the court on State of Georgia versus Mr. Clarence Lucius Mangrum, 2025 CR 02466. Mr. Mangrum, you're before the court on simple battery on a police officer, obstruction of an officer, and public drunk. What is your client plead to the offenses before the court?
Judge, he pleads guilty.
All right, by entering a plea of guilty to counts 1, 2, and 3, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony or evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On February the 2nd, 2024, officers were dispatched to 5619 North Lake Drive, located here in Clayton County, Georgia, in reference to a drunk person, quote, spazzing out. When officers arrived on scene, they made contact with the defendant before you, who officers observed that he was in a aggressive fighting stance, and at that point went to detain him. When officers attempted to detain him, the defendant did grab the officer's fingers and squeezed his hand hard. Officers did smell a strong odor of alcohol coming from his person after observing that the defendant had an alcohol bottle in his hand. Officers placed the defendant inside of the vehicle, in which he put his foot up to stop the vehicle. Additionally, the defendant did continue to make inappropriate rants and accusing the officers of being a member of the KKK. Those are the facts of the case, Your Honor. The state's recommendation is as follows. For count one will be dismissed. Count 2 and 3 will run concurrent. This is 12 months to serve. $60 days, balance suspended on the condition that he does not violate any other laws.
All right, Mr. Lynch.
Yes, Judge. Thank you. We would just ask that you accept the recommendation from the state.
All right, how much time has he served?
It served
So-
about a little over a month, maybe 30 days, Your Honor.
Okay. All right, so Mr. Mangum? Sir,
Yes, ma'am.
you what they call a mean drunk. You might want to watch that because you don't come out on the right end of that situation. First of all, if you're intoxicated, you can't make good decisions and you can't adequately defend yourself. So you out there going selling wolf tickets, but you can't defend yourself. You got me?
Yes, ma'am.
All right, so you may need to get some help. I suggest AA. I suggest you start going to AA meetings and we can avoid this situation. Everybody thinks that they're not an alcoholic or they don't have any problems with alcohol. But my theory is if alcohol ends you up in a red jumpsuit or an orange jumpsuit and you're spending 30 to 60 days in jail, you certainly have a problem with alcohol and you might want to get some help for that. AA is a great opportunity to talk to some people who've been where you are and see if you can't get out of this situation. We clear?
Yes, ma'am.
All right, so I'm going to accept your plea. Count 1 will be no pause. Count 2 and 3 will run concurrent, 12 months to serve 60 days. Balance will be suspended as long as you have no new violations of the laws of the state of Georgia. All right, Mr. Mangum, get some help, okay? You're too young to have this take over your life. All right, going back with the sheriff's office. All right, Brooks, Collier, and Watt are our last 3.
If we could do Mr. Brooks.
Based on counsel's indication that Mr. Brooks will take a plea, may the officer be excused?
Yes, ma'am, that's your witness. Y'all excuse him when you're ready.
Mr. Dorsey, Officer Dorsey, excuse me, you're excused. Thank you so much, sir.
Yes, ma'am. Thank you.
And Judge, you did indicate earlier you wanted to speak to Mr. Shealy.
Yes, you were reading my mind because that was on my mind right then. All right, let's bring out Mr. Shealy when we have an opportunity so I can impress
I
upon
wanted
him.
to do the Brooks plea first.
Yeah, that's fine. Either one.
Yeah, he's already out. That's why.
Oh, wow.
24 months probation, served 180 days. Balance probated, take a family violence intervention, substance abuse evaluation, and recommended treatment. Okay. You will plead guilty to battery family violence, and both cases will run consecutive, but it will be only 180 days to serve, not 12 months. We're ready to proceed, Your Honor.
All right, so Mr. Brooks, you're before the court on 2025 CR 00021 for Anthony Lamar Brooks. You're represented by the law firm of Lister, Holt, and Dennis, Mr. Taz Taylor. You're charged in that case with simple battery family violence count 1 and simple battery count 2. You're also before the court on case 2025 CR 00998. And you're charged in that case with family violence, count 1, battery, count 2, simple battery, family violence, count 3, and simple battery, count 4. Mr. Taz Taylor, how did your client plead to the offense? I'm sorry, Mr. Brooks, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. So how does your client plead to the offenses before the court on the case ending in 009, 00021?
Your Honor, my client pleads guilty to the simple battery family violence, count 1 in 00021, and he pleads guilty to count 1 battery family violence in case CR 00998.
All right.
The lesser charges would merge.
All right. All right, by entering a plea of guilty to count 1 on the case ending in 00021, and by entering a plea of guilty to count count one in the case ending in 00998. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Mr. Brooks, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis and recommendation, please.
Sorry, I was on mute. In the first case, Your Honor, 2025 CR 00021, I believe.
Yes.
On February the 15th, 2024, officers responded to a domestic disturbance at 681 Flint River Road in Jonesboro, Georgia, located here in Clayton County, Georgia. Officers met with Charlene Henderson Brooks, SHARLENE, Henderson, HENDERSON Brooks, BROOKS, who reported that her and her husband, later identified as the defendant, Mr. Brooks, was arguing over a dog, which turned physical. Officers spoke to a juvenile who indicated that she was woken up by a noise when she heard her mother saying, "Let go of my wrist, you're hurting my wrist." She witnessed her mother being forcefully pushed by Mr. Brooks against the back door and in the face while the defendant was holding the dog. The juvenile also stated she tried to get the dog away from Brooks, was unsuccessful. The juvenile advised officers that the defendant started to push her mom, Miss Henderson Brooks, into her, and also the juvenile witnessed Mr. Brooks push her mother forcefully in the head and then left out the front door. Those are the facts of that case. Your Honor, the state's recommendation in this case is 12 months probation, no drugs or alcohol, subject to random testing. That will run concurrent to the next case, 2025 CR 00998.
Case. 12 months probation.
In this case, Your Honor, on January the 23rd, 2025, officers responded to the same incident location, that being 681 Flint River Road, located here in Clayton County, Georgia. Officers made contact with two individuals, one being the victim, Ms. Charlene Henderson Brooks, and also Mr. Anthony Brooks. Officers learned during the course of their investigation that there was a verbal altercation that turned physical, in which the defendant hit Ms. Henderson in the face. Officers observed that she had a swollen face, busted lip, and bruising on her right arm from falling to the ground. Those are the facts of the case, Your Honor. The state's recommendation is as follows: 12 months to serve, 180 days, balance probated for the defendant to enroll in the Family Violence Intervention Program, substance abuse evaluation, any recommended treatment, and no drugs or alcohol while on probation. So essentially, Your Honor, the battery family violence will be the first case for the recommendation, and then the simple battery family violence would then run consecutive as far as probation continues. Your Honor, I did speak to the victim, Ms. Charlene Henderson Brooks, regarding contact with the defendant. Just for the record, Your Honor, it's the state's position. However, I will provide what the victim has requested from the state. She has requested to have contact, no violent harassing nature, with Mr. Anthony Brooks. Just for the record, Your Honor, the state opposed to have any contact whatsoever because of how their relationship is. However, that is the state's position, but the victim does want contact.
Mr. Taylor?
Thank you, Your Honor. That's the agreement between the defendant in the state, we ask that you accept that negotiated sentence. We do request that there be contact, although no violent or harassing contact, I think, is appropriate. Mr. Brooks is, as we discussed at a previous hearing, provides care for his wife. She does suffer from lupus and does need him in the household once he's released from custody. She does rely on him typically for transportation to medical appointments and other necessary life needs.
Mr. Brooks, when you gonna stop beating your wife? You've been beating her since that case down in Columbus. When you gonna stop? When is it gonna be enough? When you gonna deal with whatever demons you have inside you so that you don't have to put your hands on a woman?
Man, to be truly honest,
Especially a vulnerable woman who has lupus. You know what causes lupus to worsen? Stress. And beating somebody can't be good for lupus.
man, to be truly honest, I never put my hand on my wife.
Mr. Brooks.
My wife drink. My wife got a drinking problem, but I'm not trying to bring all that up. I don't drink or do drugs, period.
Okay, Mr. Brooks, we're gonna play this game. So we're gonna be in a relationship. You and I will be in a relationship for the next 2 years because these cases are running consecutive. So for 180 days, I know you won't be able to put your hands on her because you'll be in the jail. After that, you and I will be checking in with each other through probation for the following time until this 24 months is up. Mr. Brooks, when are you going to get tired of the situation that exists?
Your Honor, I've had extensive opportunities to talk with Mr. Brooks. He understands the significance of this case and the prior events that happened in Muskogee County. He and his wife have been together a substantial amount of time. I've talked to them both and explained they both agree that the Family Violence Intervention Program and getting counseling to deal with anger management issues between the two parties would be beneficial to both of them. And we're hoping that you won't see Mr. Brooks again in our courtroom.
No, because the next thing is two options, Mr. Taylor. Either I won't see him here because he's upstairs in Superior Court because he's killed her finally. So that's one of the options. Like either he gets it together and he gets himself some help, or he's going to end up killing her. So, I mean, I'm just saying it's up to Mr. Brooks what he wants to do.
Yes, Your Honor.
You can't help somebody with lupus and be their support when you beat them. Because I can't imagine that the police officer said she had a face that was swollen and puffy. She did that to herself?
She got lupus, man.
Yeah, I'm aware of what lupus is. It's an autoimmune disease and it attacks certain parts of the body. Sometimes it's it attacks the skin. Sometimes it attacks the organs. Sometimes it attacks the body systemically. So it can move from place to place. But that doesn't mean that you don't get lumped up if somebody hits you. So everything the officer saw was due to lupus. Mr. Brooks, I'm asking you. Y'all have been in this toxic relationship together for a long time, way before me and Mr. Taylor and Ms. Hagler came into the situation. You and your wife have been in this toxic situation even before y'all got married. Because back in Muskogee, listen to me, she wasn't Brooks then. She was just Henderson. Y'all chose to be in this situation together. Y'all have what, 8 kids together?
Yes, Your Honor.
I mean, it's just like, is this what do you want to get the call that one of your guys, one of your sons is doing this to his significant other and that he's in jail because this is what he saw you do? Do you want to get the call that your daughter is with somebody who treats her just like you treat her mama? You want to get that call?
No, ma'am.
Okay, because that's what you're showing them. That's what you are showing them, that you and your wife, and she's part of this too, because she's complicit in this also. She stays with you. She begs to have you back. I need him, but all of this. So this is the cycle of domestic violence that is so prevalent in situations. all of this fighting and then loving and fighting and loving and, oh, we got to be together. We love each other so much. And then there's violence. Imagine what that means for the kids in the household who don't have a choice about where they get to go or where they get to be. That you're their parents, and so they have to depend on you both. And imagine what it means to them, what kind of stress they're living under when they wake up in the middle of the night and folk are yelling, grabbing, hitting, beating, cops are coming. Imagine the psychological damage that you are doing to your kids, you and Mrs. Brooks, because this is the cycle y'all keep repeating in their face. And they don't have a choice about whether they get to stay there and see it or whether they get to leave. As minors, they got to sit there and take it. They got to listen to the thumps, the arguments, the bangs on the wall. They're in the room imagining the worst because they got to sit there while y'all do that. Mr. Brooks, these 180 days can be transformative if you are willing for them to be. You need to start thinking about how much time you want to keep spending in jail, in prison, in a jumpsuit, away from your family based on your issues. You got me? Because you make this decision. We all put ourselves in the situations we're in. When people say, oh, I caught a case. Well, how do you catch it? Because I put myself in this position to catch it. So what I'm saying to you is you got 180 days to think about how you want the rest of your life to look. I don't believe there's anybody who's irredeemable. There are very few sociopaths and psychopaths. They're irredeemable. But for somebody who can make a conscious effort to be a better person, you got 180 days to start thinking about what your life is going to look like when you get out. And whether you want to make the next generation of abusers with the last name Brooks or the next generation of victims with the last name Brooks. We clear?
Yes, ma'am.
All right. So I'm going to accept your plea of guilty, and count 2 will merge on the case 2025 CR 00021. I'll sentence you to 12 months probation to have no alcohol or illicit drugs, and you're subject to random screens for alcohol and drugs. If you have not finished the family violence intervention program, you will finish that program under that sentence. And then I'll sentence you to 12 months to serve 180 days. Balance will be probated for you to take a family violence intervention program, substance abuse evaluation, and any treatment offered or ordered, no alcohol or illicit drugs, and you're subject to random screens for alcohol or illicit drugs. And that's case 2025 CR 0098998. Is it 998? So we'll make sure I get the number right. Oh, 998. So 99, the case ending in 00021 will run consecutive to the case ending in 00998. So Ms. Wright, did you get that?
Yes,
Counts
ma'am, I
2.
got it.
All right, thank you. Counts 2, 3, and 4 will merge in that case. All right, so Mr. Brooks, you got 180 days in the Clayton County Jail, or however long the sheriff counts that. I don't get involved in that. But what I do say to you, sir, is please, please, please make a decision about how you want your life to go. How old are you, sir?
53.
How?
53, ma'am.
How do you want the rest of your life in an orange jumpsuit, in and out of an institution?
I don't want to be here now, ma'am.
Exactly. So I need you to start thinking about how you're gonna make some changes. When that anger flares up in you, what you gonna do next? What's the out that you will give yourself other than something that gets you right here back in front of me? We clear?
Yes, ma'am.
All right. You can go back to the sheriff's office.
Thank you.
Next.
Judge, I did have an announcement on Mr. Collier. I would request that this be continued to the next jail calendar.
Okay,
Judge,
no problem.
we
Let's
may need-
continue Mr. Collier to the next Tuesday calendar, please. All right, what's up with Watt? And I want to talk to Shealy.
You want to go ahead and do Shealy and then?
Yeah.
Just gonna give Mr. Shealy a quick advisement before you go forward, Judge.
And Your Honor, after you all conclude with Philly, if we could just go back to the Chantrell Ellis case, I want to confirm something once we're done with the Shealy case.
Okay, on Ellis, I
Okay.
have that he's entered a not guilty for both, or she's entered a not guilty for both. And then I gave a bond of $3,000 per offense on the second case. What's the issue?
So after further research, it appears that the case ending in 02952, she was already given a bond by the magistrate judge in the amount of $20,000 each. So the $3,000 bond should be applied to the case ending in 02949 because that case did not have a bond.
Okay, that works. Thank you.
Okay, you're welcome.
Is this Mr. Shealy?
Judge, this is Mr. Shealy.
Mr. Shealy, you racked up 2 cases in front of me and they're both having violence in them. So you are not guilty until you're proven guilty. But I do want to advise you, sir, that should you make a bond, I am very serious about the bond conditions in these 2 cases. Mr. Lynch is indicating it's not likely you'll make a bond. Not sure about that. But sir, please remember, when I say no contact, I mean no contact. That's calling, writing, texting, having somebody else reach out to somebody. Please don't try me with this, sir, because you ignored my bond conditions on the first case and ended up getting the second case. So please, sir, I don't want you to talk. I just want you to understand that if you were to violate my bond conditions, and that even includes telephone calls, then you are subject to staying in jail until your cases are resolved. You're also subject to being charged with additional misdemeanors and felonies. Do you understand?
Yes, ma'am.
All right. You can go back with the sheriff's office.
I think Watt is the only thing we have left to actually do, right?
All right. Watt is my last case.
Better, come on.
All right, Ms. Watt, you back so soon. Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. You're before the court for a bond, I'm sorry, petition for probation revocation on case 2024 CR 00964, Alicia Brooke Watt. You were before this court on the 28th day of January 2025 for theft by shoplifting. You were sentenced to 12 months on probation. You have 10 months and 10 days remaining. The sentence was not told. You have been arrested for VGCSA on March 2nd, 2025 in Clayton County. You failed to report. You've never actually reported. You were directed to report on March 3rd of 2025. You have failed to provide proof of completing 50 hours community service. You failed to pay, and you're $100 in arrears. So before you could even get out good on the street, you got back in jail. All right, Mr. Taylor, what are we doing with?
Your Honor, I believe Mr. Austin has a recommendation.
All right, are we admitting to the technicals?
We are stipulating, I apologize, Your Honor, we're stipulating to the technicals and and we also will agree with the recommendation. And I believe the recommendation was 60 days to serve and to close the case.
That is correct, Your Honor.
All right, that works.
And Your Honor, I've spoken with Ms. Watt a couple of times now, and we have a plan. Hopefully, once she's resolved her cases here in Clayton County, or at least resolved them to the point where she'll gain her release, we're looking at a rehab program for her.
Okay, well, Ms. Watt has needed a rehab program for some years now. This is not her first rodeo, so I hope she gets it and stays and does the work. But yeah, Ms. Watt definitely needs a rehab program.
Yes, Your Honor. What she can do is order you to do one, but she's not going to be the person that probation can help you do. Well,
All right, so I have defendant shall have 60 days revoked after service of 60 days in the Clayton County Jail. Defendant's case shall be closed. Is that the
Yes,
agreement?
That's correct, Your Honor.
All right. Ms. Watt, the only thing that can happen is you make the decision to have a better life. Otherwise, you're gonna stay in this circle until it ends. And you know, the drugs ain't what they used to be, Ms. Watt. So you could pop up on some fentanyl or something worse at any given time because you know, it's not like going through to reputable pharmaceutical merchants. Whatever they've given you, you could end up with a hot shot. So what I'm telling you is you got to make a decision about how long you want to do this. How old are you, ma'am?
I'm 36.
Okay. You want to go into your 40s, drugging and stealing and doing stupidness?
No, ma'am.
All right. So take this 60 days and figure out what you're going to do with your life.
Okay.
All right. You can go back with the sheriff's office.
thank you, Your Honor.
All right. Send over bench warrant recalls, no crosses, anything you got, I'm signing. All right. Take care, everybody.
Thank you, Your Honor.
You're welcome, Mr. Austin.
Your Honor, we do have one more case that you can just
We got
give
what?
us a few minutes for on the criminal Coleman.
Who?
Coleman, he should be in the courtroom unless Attorney Taylor gave a different announcement that I wasn't aware of.
I'm sorry, I can't understand what you're saying. You keep glitching. You said who?
Okay, I'm sorry. Coleman, Your Honor. I'm not sure if he's still in the courtroom. That was Mr.
Yes,
Taylor's case.
Mr. Coleman's present, and we're just waiting on the information from the state.
Okay, yes. Give me a few minutes, Mr. Taylor. We should be able to resolve that case. Give me a few minutes.
All right.
Your Honor, what was the announcement on Miss Ellis's bond?
$3,000 on the one case that she didn't have a bond.
Right. So for
She had the case with the two charges, my understanding is it had a $20,000 bond per charge.
yes.
That's per Ms. Hagler's information. The remaining case said she did not have a bond on. I'm giving her a $3,000 bond.
Oh, okay.
Yeah, so the case ending in 02949, that is the one the $3,000 should be applied to, because the case ending in 02952 already has $20,000 for each based on the magistrate information, the bond order.
Okay, I didn't have a copy of the bond order. I was just looking at what classifications had listed on the active inmate website.
Okay, yeah. And so give us a few minutes, we should be able to work out. The state is gonna not process the battery family violence. And as we mentioned, all of the conditions will just be moved to the battery, and the remaining charges will merge.
Meaning, okay, battery, that will be a guilty plea, 12 months probation, $300 fine, 40 hours community service, anger management, and
Sorry, I have an update. I am going to not process that case altogether. So I will prepare a not process order for the judge to sign.
no process to the entire case?
Yes,
Oh.
and I'll prepare a not process right now for the judge to sign.
Thank you, Ms. Hagler.
You're welcome.
Mr. Taylor Coleman is done.
Yes, Your Honor, the second not process case, I'm going to prepare a not process order for your signature.
All right. That concludes the 3/18/2025 calendar. Thank you all. See you on.
Good day,
Judge,
Judge.
will you hang back?
I'm sorry.
Would you mind hanging back after you end the Zoom call?
I'll just come on again.
Okay.
All right. Thanks, Whit.